Did I hear you say yes? I'm sorry.
Yes.
Okay, thank you. All right. Anything else? Go right ahead, Ms. Clawson.
Thank you. This is a case about the public's right to transparency and the integrity of our safety evaluation process. I'm here today requesting documents that were unlawfully denied to me 2 years ago as I ran for Lieutenant Governor against Henderson, who was also serving as a chief election officer of the state. In March of 2024, Lieutenant Governor Henderson declared that she had reached the legal threshold of 28,000 signatures to appear on the primary ballot. The following month of Utah GOP convention, Cox and Henderson only received 32% of the state delegate vote, compared to the Lyman who received 68%. And according to the Utah, our constitution, GOP constitution, our convention rules, we should have gone directly to the general ballot with over 60% of the vote. So, but he said that he submitted enough signatures that it should be qualified. So naturally, I wanted to view these petition packets and to see them in person to see what was being used to put us into the primary. So, more than 2 weeks before the primary, I went to the Lieutenant Governor's office and I asked to have a complete copy of the records. I wanted to see them in full, and I wanted a complete set of these documents. And I expected that my request would be honored. I talked to several people who got into the Lieutenant Governor's office and received permission to view packets for other candidates and other county clerks. Allowed that to happen. I'd never heard of them ever being denied, so I expected to be able to see those. And I did this before the primary, but my request was denied. We wanted to verify this information before the primary election. It was critical. The timing was critical. And I was only given a partial document where 40% of the document was concealed and where the voter information was completely redacted. All it had on there, on each of these 40% of these lines, was just the county name. It didn't have names, it didn't have addresses or anything for those voters, for those signers. The LGL responded and said that I could not, she said, you can't see these packets. If you want to look at them, we will redact them, and as soon as you could see them is the end of July, which was after the certification date. So the Lieutenant Governor stated publicly that state law would not allow me to see it, but didn't explain why it allowed her to show other packets and what the state law was that wouldn't let us look at it. So we've put considerable time and expense to try to do these packets. It's been 2 years, and so we're asking you today to allow us to see these. The only thing that was requested from those original requests from the other people and my request was the actual candidate, and that's why it was being concealed. A petition is public, and the voter laws don't apply to a petition. It should be viewed. That's how it's always been treated. But even if they did apply, and you use the privacy and withheld laws, it's clear. The legislative intent is clear in 28-2-104 that candidates are explicitly given the right to view these private things. It says in there, if you sign, you want to be a private voter, you understand candidates have a right to view these things. We use that in court, and the Lieutenant Governor used that same section in court, but omitted that part that applies to candidates. And the court omitted that part. And no one has ever explained why you can't see those as candidates. I should have more of a right to do it than these other individuals who went to do packets as a candidate. And I was the one who ran against her. And so it should have been my right to see these. The court was inaccurate when it ruled that it was a transparent process and 29 clerks were involved. There was only one clerk, and that clerk had the contract with the Lieutenant Governor herself to be able to view all the packets. And so the court ruling was out of order because of that. There were several things that they were relying on this information that was given by the Lieutenant Governor's office and other things to rule that way. So we're bringing this Gramma request today because we believe that there's newly discovered information that I didn't have at the time, that we know now. We know about forgeries on Cox's packet. We knew that the Attorney General was investigating these forgeries starting in March of 2024, before the campaign, before the primary. And we know about an extensive cover on those names, where people hid that information from us intentionally through the Gramma process and through the court, and so that we were not able to see that. And these petitions were directly related to my own election, and they were intentionally concealed to us. So the director can now restore some faith to the system and to the over 200,000 people who wrote us in on the ballot and who are paid attention and
watching what is happening today, you can restore some faith in the system by allowing us now to see the packets. It's 2 years later, it wasn't given to us timely, but there's no reason why they are being denied to us. Our privacy laws are not meant to protect fraud. They are supposed to prevent fraud. And here they are using to protect actual fraud. So the things that we know now, there is so much that was going on behind the scenes we didn't know at the time. We know now that number one, Cox did not submit the required number of signatures. He was short. We know number two, the circulators, there are circulators who are charged with submitting forgeries on Senator Don Ips's packets. They told investigators that they also charged for that they were also forged for Spencer Cox. They knew that during the election cycle. These same investigators who knew that information, then they met with members of the Lieutenant Governor's office to express concern about Cox's shortfall in signatures. All of this is before the ballot was printed. They knew about these concerns. The forgeries, at number four, we know the forgeries on Ipson's packets were so obvious that one could see it with their naked eye. Number five, in relation to my Gramma request, I asked, we know there's a criminal investigation on Don Ipson's packet and it's been circulated for scouting for Spencer Cox. I asked, are there forgeries on Cox's packets because they likely are on both packets? And they ignored my question. They never responded to it. So not only did they deny the documents, they didn't even respond to the questions. This is before the primary. Number six, we knew the AG's office opened a criminal investigation into these forgeries that started clear back in April 2024. And that was denied to us. Every Gramma request that Michael Clare made to find out information about that was denied, starting with the director here and other people in the Attorney General's office, and then to the 3rd District Court. It was denied to the court. And it wasn't until a whistleblower came forward with the exact document that we've been requesting, with the investigator's name and the number that we knew of and we were asking for a year and a half. And it wasn't until the whistleblower gave us that document that we were able to confirm that information. So this was intentionally concealed from us. Number seven, we know the Lieutenant Governor's office concealed this investigation of this criminal investigation into this widespread forgeries used by Governor Cox and Lieutenant Governor Henderson to place them on the 2024 ballot. Number eight, because these documents were denied to us, we were not able to use them in our court case. The court said that this was a transparent process. They didn't know about these forgeries. They didn't know about these investigations. It was denied. So number nine, we know your involvement in it. We know that you submitted, that Michael Clare submitted a Gramma request to the AG's office in 2024. Michael knew the investigator's name, the case number, because the victims themselves of the forgery had contacted us and told us about that they had been interviewed by the Special Agent Jordan McKell and Director, and we know that you were serving as a records office at the time and that you denied that Gramma request, saying that there was no responsive documents. And lastly, number 10, Michael's request for information about the criminal investigation was repeatedly denied by the AG's office for information about the criminal investigation, and then was repeatedly denied up to the court. And it wasn't until we had that whistleblower's information. So because of this new evidence produced by this whistleblower, the court recently in January reopened the case under Rule 60B motion that allows for more discovery. So we ask you today to do the right thing, to release these documents that were unlawfully denied to us 2 years ago. And we understand now the intent why it was denied. We understand now the forgeries and that were involved in it. And we ask you to release the full signature packets, which we had asked for initially, and that we have the legal right to view, and allow us to view the packets in full. Thank you.
Okay, thank you. Do you want to go, Mr. Maragani, or do you?
No, we were going to do a rebuttal.
Okay. The one question I had to start off with is, it sounds to me honestly like really you're trying to relitigate the 2024 request.
No.
Can you tell me how that request is different from the present request? Because honestly, most of the time that you just spent was talking about things that were related to the previous request. So go ahead, maybe you can address that.
No, we're not trying to relitigate it. We brought the request back then, but there's different information that we know now that was held back. That was we were denied information, and because we know about all the fraudulent signatures and things like that, the situation is much different now than it was at the time. And it was improperly decided because they relied on it being a transparent process, and the court, there's key information that was held back from the court, and that was not allowed for us to use it in our case. And so the So this is definitely related to the 24 request, because it is the same request, but we want to show that the director today, that it was improperly decided because of this information that we know today.
Okay.
I don't know if you want to add to that.
If I could just add, I mean, in the LGO's response, they actually raised the 2024 original request that Ms. Clawson did. And so it's our view that that is now an issue here. And if you go back and look at that, the LGO concealed material information from the court in that situation. So for example, at the time that Ms. Clawson made her request, the LGO was aware that there were multiple criminal investigations going on into forgeries on Governor Cox's signature petitions, and they did not disclose that to Ms. Clawson, and they did not disclose that to the court. And so when the court went through and they weighed whether the interests were under Gramma, whether the interest was in transparency or in privacy, they didn't have information that probably would have swayed the decision that the court made. So now we have that information, and we have it, as Ms. Clawson said, because a whistleblower came forward and produced an unredacted copy of AG 24-170. And so we're asking you to now go back and do almost kind of a Rule 60B in this case, to look at that and consider that there is new evidence that we have that shows that what happened back then was actually based on concealment by the LGO's office.
Okay, that's very helpful, thank you. And that was my impression, is that's essentially what you're looking for, based on the new evidence, as you said. Okay, thank you. We'll go to Mr. Cheney for the respondent.
Thank you, Director. Before I talk about the law that the Lieutenant Governor's office has applied to this most recent Gramma request, I want to address a couple of points that Ms. Clawson has raised, and the first goes to the role of this tribunal, the Government Records Office, as there seems to be a mistaken conclusion that this tribunal is an appellate court or has some kind of authority to revisit matters that were determined in the courts and appealed through the courts and through the court process, and have long since been dismissed. And so that's one thing I want to point out. I also want to point out that the Lieutenant Governor hasn't, and purposefully has not, addressed the kind of accusations and conclusory slander, I guess, for want of a better word, but she's mentioned actual fraud, forgery, cover-up, intentional concealment, and brought in a number of other requests that aren't before the Government Records Office this morning. And so, to the extent that all of that, including the written statement of facts, I want to make a general denial for the record and make it clear that we're here today to discuss this particular November request for records, and that all of the discussion as to why and what and how and other requests and reports and the petitions and the campaign aren't really relevant here, and again, a general denial, and for the record, want to make sure that our not addressing it point by point is not interpreted as some kind of acquiescence or acknowledgement of any of those allegations. Okay, as to the Lieutenant Governor's denial of the November 2025 request for nomination petition packets and the signatures and the names, I will state that Mr. Maragani right, the Lieutenant Governor did raise the 2024 Gramma requests in response to the November request, solely for the purpose to recognize that this request has happened before. It's been before it's gone through the Gramma process. They made a direct appeal to the courts as Gramma allows for judicial review, and accordingly, you feel like nothing really is different between this and the 2024 request. It seeks the same packets, the same information, the same records, and essentially the same law applies to explain how the privacy laws do in fact affect access to records in this case. And as was significantly litigated in the third district court in the first time around, the express provisions of Gramma at 305.5, that is 63G2 305.5, refer to 63G 302.74, I think it's 302.74, and also back to the election code and the provisions there. The Gramma statute says that it says that names and signatures of people who sign a political petition, that information is not public and can be produced in two manners. One is that the custodian of the packets, in this case the election officers, can make a list and provide that list of signers to the requester, and that's subject, of course, to the privacy provisions, which relate back to 28.2.104H, which allows voters, when they register to vote, to check the box that says they elect to have their voter registration information kept as private. Now, back in 2024, and again in November and December, in relation to this particular Gramma request, the Lieutenant Governor's office provided a list of the names of the signers of those candidate nomination petitions, and offered, as the statute allows, to make those available for in-person inspection, subject to the privacy and withheld provisions of the code. And that's what we've done. That's the very process that the court said the LG correctly applied, and in his decision at the third district court. And so, from the perspective of what's happened and what does the Gramma law allow or require, our position is that the Lieutenant Governor's office responded and provided the type of access to these records that the statute allows, both at the time and then most recently. As you know, in our statement of facts and in the record relating to the November request, Lieutenant Governor's office also has cited a fairly recent provision of the election code, which is 28-9-408.1, which interestingly, took effect after the 2025 session of the legislature, which was, of course, after the primaries, after the general election in 2024, and the legislature imposed kind of a stricter window of time and conditions wherein candidate nomination petitions can be accessed and viewed by the public. And under that provision, and this is subsection 5 of 20A9-408.1, sub 5, it says that B, no person may access or view the candidate nomination document except the lieutenant governor, the legislative auditor general, or as ordered by a court with jurisdiction. And then relating back to sub 4, an individual described in subsection 1 may not view a candidate nomination document after the election officer certifies the results of the primary election race to which the candidate nomination document relates. So, and then finally, in that provision, what the legislature kind of put in place is that candidate nomination petitions will be, after the election has been certified, election officers are instructed by statute to seal and store those candidate nomination petitions for 22 months after the election, and that then no person can view them except as noted in sub B that I just read. So we're relying on the application of a number of provisions of both Gramma and of the election code. And as you know, in subsection 107 of the Gramma code, it says Gramma applies except to the extent that access to a particular record or series of records is governed by another state statute, court order, federal statute, etc. Under that provision, we can say, okay, the election code as to political campaign petitions, the signatures, names, and voter information, the election code provisions expressly and specifically address how those records are to be handled, stored, accessed. And it's reliance on that election code, of course, that election officers, the lieutenant governor's office and all of the county clerks are bound to follow. So that's what has happened here. Those provisions of the statute are what kind of governs the analysis, and they're really the only relevant analysis that goes into this proceeding. And that's what we've done. That's what the statute requires, and that's what the court has upheld. And so we feel like this is kind of a matter that's already been decided, but nonetheless defer to the Government Records Office, and appreciate your attention to the matter. Thank you.
Okay, thank you, Mr. Cheney. I did have one question. You mentioned that you think that there's really nothing different between this request and the earlier request. Why didn't the Lieutenant Governor's Office treat it as an unreasonably duplicative request and just decline to fulfill it on that basis?
In an abundance of caution, I guess, and rather than try to argue the duplicativeness, et cetera, which I think we have in our briefing here, certainly in the response response at the administrative level, the office cited the June 2024 request and the appeal of that request and the court case. All of that has been included in the record at the Lieutenant Governor's office, level, which is why we can bring it up here again. But taking on just a separate kind of analysis as to duplicative, we just elected that that analysis would also be duplicative in the sense that we identified how the two requests are related and are essentially one and the same.
Okay, thank you. All right, we'll go back to Tisher.
Just one second.
Sure.
Okay. Well, just a couple of things. I'll just go through some of what Mr. Cheney just addressed. First of all, I know he brought up the 2024 district court case. If you notice, the LGO is using that to argue, I think, race judicata. And our point is that when you go and you look at that case, it's very clear that the Lieutenant Governor's office omitted material information from the court when they filed a motion to dismiss. And specifically, they didn't mention, for example, that there was a criminal investigation going on, AG 24-170, and that included 18 of Governor Cox's signature packets that contained 858 forged signatures in them. At the time that they were briefing in the district court, they knew about that. They didn't disclose that to the district court. And so it would be difficult to now argue that the court's decision was race judicata when they were not given full information as they should have been. And I just want to add, if you look at that district court case, the court actually says that to decide whether to release private data, they can do that balancing test allowed under Gramma. So balancing those transparency interests against privacy interests. And in doing that, the court actually says, and this is because, again, they weren't given the information about the forged signatures. Second, the court recognizes and acknowledges the myriad identity fraud related or otherwise concerns for most voters related to the prospect of their signatures from election petitions they have signed being disseminated by the LGO outside government offices to third parties. So the court here is thinking that they're protecting people from identity fraud by not releasing this information, when in reality, the identity fraud was that the information was inputted onto the petitions themselves. There were, like I said, on the 18 petitions that were in AG 24-170, there were 858 forgeries out of 900 signatures. Those were not put in there by voters. Those were put in by signature gatherers that were hired by Governor Cox and Lieutenant Governor Henderson. That is not data that should be hidden from the public on privacy laws meant to protect voter data. And I don't think, and that failure to actually disclose that material information to the court is why this body actually should not use that as race judicata. The facts are now different. We now know a lot more than we did back then, partly because a whistleblower came forward with that report like we talked about earlier. Mr. Cheney also said that we were accusing them of making conclusory statements and slanderous statements. I'll just add, we don't have the signature petitions. So he's again speaking as someone who can look at the signature petitions and then telling us that we're making slanderous statements. Well, I would say that's another justification for releasing the petitions. If you're gonna throw out accusations like that, then you should back them up with evidence. So let us see the petitions. And I'll just add that I've seen Don Ibsen's petitions, and the fraud is obvious. You don't have to compare the signatures to signatures on file that the LGO has. all you have to do is look at the entries, and it's obvious one person wrote every single entry on the petition and just turned them in. That's how obvious the fraud is. And they're now trying to cover that up so the public can't see it. And it's our view that this is being done to protect people's political careers. And specifically, if this stuff comes out and people see how obvious it is, I think it makes the lieutenant governor look really bad and destroys her political career. Now, that's not my problem, right? When you go through these types of processes and you do that, there's ramifications for it. And I don't think Gramma law should be used to protect the public from seeing that. He kept talking about the 24 request. They raised it. They raised it. The LGO raised it in their response to Ms. Clawson's appeal. So now it is an issue. They're the ones that are raising it. We didn't raise it, they raised it. And so now we are asking you to go back and look at it again based on the information that we have today that we did not have at that time. He talked about the list of signers that the lieutenant governor's office provided, where they redacted 40% of the data. As Ms. Clawson said, all she has is the county that these people were located in. Well, within that, just as one point, there are people whose information was forged on the petition, so they did not sign it. The voter did not sign it. They have nothing to do with this. The voter actually, I don't even think that the voters know that their names were placed on these petitions by the signers, that they were forged. They have no idea to this day. They might have said, I'm making my information private to protect my identity, and then some signature gatherer goes out and forges their petition, or their signature on the petition, their name, and they have no idea that that's happened because it's being hidden by the lieutenant governor's office. We need that data. In fact, I'll just be honest with you, my information is private. What if my information shows up on that petition? I know I didn't sign it. I should have a right to see it.
I've had a lot of people reach out and ask if what their names are on there. They're concerned and they wanted to know, so it's a real concern.
Yeah.
And some of those victims have contacted us too, with those forgeries.
So that gives you a sense that there's a lot of interest from the victim's perspective. There's at least 858. There's probably multiple thousands of them. I think Mr. Cheney has a better idea because maybe he's seen the petitions, we haven't. Now, he also talks about the LGO provided a list and offered to make available for in-person inspection the petitions. But notably, and I think this is critical, they offered to make them available after certification happened. After certification, not before. And that's our point about saying, we think this was done on purpose. If you were trying to be transparent, you would have done it before certification. So she could have seen the petitions. She probably would have come out and said, oh, these are all forged. We're gonna go to the court and we're gonna challenge their placement on the primary ballot and be able to do it based on evidence that I have seen with my own eyes. But that's not what happened. The lieutenant governor's office came back and said, it will take us until after certification, conveniently, to let you come and see these signature petitions. And then I wanna add, Mr. Cheney referred to the recent law. This was 20A-9-408.1, and this says that a candidate who is seeking, and so at the time she would have been a candidate. Now this law went into effect in 2025. I think if you're going by the 2024 Gramma request and reconsidering that, this law would not apply because you can't retroactively apply laws unless it's explicit in the law, and it's not here. But if you're going to apply this, so a candidate who is seeking to qualify for placement on the primary election ballot for the same office and party as the candidate to whose nomination petition the candidate nomination document relates, or an individual representing the candidate's campaign. So she would have been able to see this. Then what it says, and I think this is important too.
Can I just ask you on that? That's what's going on here? Is Ms. Clawson is trying to certify for the ballot?
No,
Currently?
No, but let me finish.
Okay.
This is the point. Then it says in subsection 5, after an election officer certifies the results of the primary election race to which a candidate nomination document relates, no person may access or view the candidate nomination document except the lieutenant governor, the legislative auditor general, or as ordered by a court with jurisdiction. The point here, though, is that this assumes that she would have been able to see the petitions before certification happened. The statute assumes that. Now, if the argument now is that the lieutenant governor can just delay past certification and then go ahead and seal the documents, then this law is pointless. But I think this law, the way it is written, it assumes that you would have seen the petitions as a candidate, and then they can seal the records. She has never seen them. To this day, she hasn't seen them. And we know that there's forgeries in them. So, just counter to what Mr. Cheney says, we know that there's forgeries. It has been documented. Like I said, I know there's 858 on 18 of Governor Cox's signature petitions because those are actually specifically mentioned in AG 24-170. And that's only because I have the unredacted version of it. In AG 24-320, they gave me a redacted version. I don't think it says the number of forgeries on those petitions. I don't remember for sure. Now the other point is, Mr. Cheney brought up the duplicative issue, but I'll just add, they didn't raise that in their briefing. And so to raise it now and say it's duplicative, well, you made totally different arguments at this point about the laws that apply. Although you did bring in this as a res judicata argument, because you're trying to say, well, this district court case applies. But again, the only entity in that case that understood that there were forgeries on the petitions was the LGO's office. Ms. Clawson didn't know how many forgeries were on those petitions, but Mr. Cheney knew, Lieutenant Governor Henderson knew, the Director of Elections, Ryan Cowley, knew, and they didn't disclose that to the court. So to come forward now and say, well, this is res judicata, well, you didn't give them material information. That court's decision, I think, would have been completely different if they knew the extent of the fraud on those signature petitions. And that's critical. All right, anything else?
That's good. Yeah, there's two sections of code that Mr. Cheney brought up. One is 63G that says the names of signatures are not public. Well, we didn't want the signatures, we wanted a list of names, and they did provide 60% of those names. So there's no reason why they didn't, that section of code clearly allowed for them to show those names on those packets. But he did rely on the section 28-2-104 as a reason for the private withheld names to be redacted. But again, I go back to that same section. Again, the same thing, we're seeing the same pattern that we saw when we were at Gramma, the Gramma hearing before, and at court where Lieutenant Governor's office is bringing up that section of code, but again fails to discuss the part that says in the code and on voter registration form, it says, yes, I request that all information on my voter records be withheld from all persons other than government entities, political parties, candidates for public office. So why does that not apply? And then it goes on and says, and their contractors. We know now that Spencer Cox's contractors had access to the private withheld names to be able to gather that information. They gave them to the contractors, but they did not provide it to us as candidates. So if he wants to argue that section of code, that must be explained why this doesn't relate to us now, because we should have the private names, and at minimum, we should have the addresses from all the withheld, because those it does not deny to us. It is actually explicitly given us that this ability to view by the legislature. This is their intent.
Okay, thank you very much. We'll go back to you, Mr. Cheney. Your rebuttal, please.
Thank you. I want to say that a lot of Ms. Clawson's argument has to do with what I would call the process or the procedure that is statutorily defined and which has been applied to many candidates' frustration over the last several years. And I get that. It is a frustrating procedure, and there are many questions that have been brought up both in legislature, in the courts, and before this tribunal as well. But the procedure is what it is. It's in the statute, and while it is clearly not satisfactory to most people, it is nonetheless the law, and it's the law that the lieutenant governor and the election officers throughout the state have to apply. They have no discretion to say, well, despite this provision that says, a private or withheld voter's name and signature and information should be kept private, we're gonna go ahead and hand it over anyway. We just don't have that discretion, and nor does this body. They're asking the government records office, it sounds to me like, to reopen a case that's been filed in the courts and was appealed through the court process. And if there was new information or any basis for revisiting that lawsuit, that case, the correct forum to do that would be in the appellate courts or bring another action in the district court. It's not within, as I understand it, it's not within the government records office authority to revisit what's already been decided in the courts. I also want to say that Mr. Maragani assumes that the lieutenant governor or the governor or I or anyone in the LG's office has or had any sort of knowledge of how many or whether or which ones signatures were forged. The process for determining forgeries and invalid signatures takes place at the county clerk's office, and in this situation it certainly did. And to say that the new information is that there were investigations going on, that's not new information. I mean, in the first request for these records, and again here, the petitioners have cited to the Washington County investigation and the Ipsen signatures and all of that. And so, this idea that maybe the signature gatherers had submitted signatures that weren't actually valid, that's not new information to anybody. And of course, after those pages are handed over to local law enforcement for investigation, nobody reports to the lieutenant governor's office on those sorts of things. But regardless, one thing, any signatures that were flagged as potential forgeries were not included in the total tally of signatures counted, and that process takes place at the county clerk level. So I don't want to suggest that there's any information or evidence that improper names were actually counted toward a tally. And that just goes to show the strength of the safeguards built into the system, which is the trained election officers validating one by one petition signers' signatures, and all evidence having come from that 2024 election cycle is that the system worked. But again, that's not for this this body to determine. And so I get the frustration. I understand that the procedure is not necessarily satisfactory to all who want it to be, but that's a matter for the legislature and or the courts. And as for the November 2025 request for records, request for signature, campaign nomination signature packets, I guess you'd call it, the Lieutenant Governor applied the applicable provisions of both the Gramma statute and the election code and proffered the kind of access that the statute contemplates, and that's really the limit to what her office could do in this situation.
Okay, thank you. Does Ms. Topic need to add anything, or?
No, thank you.
Okay, thank you. I did have one question for you, Mr. Cheney, and that is regarding the argument in your statement of facts about the exceptional circumstances. I didn't quite understand that argument. Is that a standard that I should be taking into account here? My understanding from reading the district court decision that the exceptional circumstances was addressed as grounds for not considering in a Gramma petition claims that were not Gramma based, essentially. But maybe I misunderstood that. Maybe you can clarify.
Well, I think that's right, and well, it is right. And the court opinion that you've read refers back to that, and our argument refers to that phrase simply to reiterate that the court had before it not only the Gramma application question, but a couple of other causes of action that were not related to judicial review of the Gramma compliance, and the court held that in the absence of some sort of exceptional circumstance that would make it imperative that the court address those issues or those causes of action in that proceeding at that time, and the court held that there were no exceptional circumstances that would justify that, nor would it justify at the time before the court was a TRO, and so in denying the TRO, the court cited that.
Okay.
Finding of exceptional circumstances. So, sorry if that was a misleading quote.
No problem. Thank you for clarifying. I'll go ahead and let you have the final word, Ms. Clawson.
Yeah, he's again going back to that same section of code. I still have that question. Why are candidates not given access to these names? Why does that? I mean, I honestly would like to know from Mr. Cheney, because we've had several hearings, and it's every time it's omitted, he continues to refer to the same section of code. Anyway, about the privacy code is 28.2-104, and again, he omits the section that says that people with a request to be private, they say, I request it to be, my information to be withheld from all persons other than candidates for public office. Please explain that.
And can we just before we get there, there's a couple more things.
Yeah.
I know that you said that there's no new information here. I think what's critical is, again, what we said at the time of the district court case that he is now citing as race judicata. They knew, and Mr. Cheney says he didn't know, but I can tell you, I've read AG 24-170. Ryan Cowley knew. He's the director of elections. I think Mr. Cheney works very closely with him. That there were forgeries. There were lots of forgeries in their petitions, and they did not disclose that to the district court, and that impacted the analysis that the district court put out. The point is, that impacts whether this body is then required to consider that as race judicata. There are different facts at play. For race judicata to apply, you need to have the same factual situation. That's not what's going on here. The second thing is he again talked about that there were none of the forged signatures were included in the totals put out for Governor Cox and Lieutenant Governor Henderson. I'll just add, we have no way to verify that. Nobody here has seen these petitions. Apparently, maybe he's seen them, I don't know, but we have not seen them. The public has not seen them. We're being asked to just believe people who were involved in allowing candidates to be put onto the GOP primary ballot when they did not have the required 28,000 signatures to get on it. I think at this point, we're not asking to go relitigate the 2024 election, but we do think at this point that there's full transparency is what's required. That's what the public wants. And Gramma allows you to do that. And I'll just add, I think the statute that Mr. Cheney is setting for 2025 also allows you to do that, because it says, after an election officer certifies the results of the primary election race to which a candidate nomination document relates, no person may access or view the candidate nomination document except as ordered by a court with jurisdiction. I would argue that this body is the equivalent of a court with jurisdiction, because this is going through the Gramma process. You have every ability to order that these petitions be made public. I think when you weigh this under the Gramma statute, again, those privacy interests against transparency, I think transparency wins out here. Again, at the least, we would argue we want the full signature petitions to be released. If you're not willing to do that, we'd actually ask that you go in and you do an in-camera review, and then every single forged name on those petitions be released to the public. Again, the people whose names were forged are victims, and they have a right to know that a private company used their information, a private company hired by elected officials used their information for improper purposes, so that they can take and rectify the action there. And now I'll go back, and now.
Yeah, and also, there have been audits that have been done that showed that there were fraudulent signatures that were counted. And so we do know that some of them were counted. We don't have the whole picture on that, and that's one of the reasons why we're here today.
Okay, thank you very much. I really appreciate the presentations that have been made today. I appreciate all the materials that you submitted. I do think, as you said, these are very important issues of public concern, and I can understand why the public is interested in this and why you're seeking the disclosure. That said, I do find that this present request unreasonably duplicates the prior request that was made in 2024. And for that reason, the respondent was not required to fulfill this request pursuant to 201-784 of Gramma. I think you're making an argument that is not unreasonably duplicative because there's new evidence and you believe that there's new facts that weren't considered. I'm not entirely persuaded by that makes it not unreasonably duplicative. But that said, I do think that this appeal is barred by res judicata claim preclusion. This appeal involves the exact same parties, the same request for records. It's essentially the exact same claim that was presented in the request, the petition for judicial review for the district court regarding the original 2024 request. As you know, the district court dismissed that Gramma appeal for failure to state a claim, finding that the Lieutenant Governor's Office acted appropriately as a matter of law. It is clear from your statement of facts that you're seeking essentially to overturn that determination, as you said, based on your assertion that there's new evidence. But I don't think Gramma gives me subject matter jurisdiction to review a district court's decision, even on a claim that there is new evidence. And for this reason, because I find that the decision in Clawson v. Henderson is controlling here under the doctrine of res judicata, this appeal is denied. I will issue a written decision within 7 business days, and you can appeal the district court within 3 days. Thank you again for your presentations and your time here today.
Boom.
Surprise, surprise, huh? Surprise.
Wow.
Look in the mirror.
That's so bad.
You know what you're hiding. Y'all know what you're hiding.
That's so bad.
Oh, gosh. Joke. Sleep at night. He said no. You'll never care why. You'll never care in your statement is good by that code.
Hey, you guys, last time we were here, they turn on these cameras and they listen to everything you guys are saying. Go out here.
Smart. That was really, really, really bad.
No, same thing, still not
We have zero trust in our elections, and you guys are covering it up.
Good job. Sorry.
That doesn't all work out, right?
Clear, lucid, reasonable request.